Hello, everyone, and welcome to the Dissenter update for June 16th. There have been over 50 incidents of attacks on freedom of the press in Los Angeles by both the LA Sheriff's Department, the LAPD, and then also ICE and the National Guard being involved as well. The last week has been marred by numerous incidents tracked by Adam Rose of the Los Angeles Press Club, who has tracked the incidents and been chronicling what independent journalists, local journalists, even corporate journalists have had to deal with while they're on the ground covering these protests. But let's get to the show. I'm Kevin Gosztola, the Dissenter newsletter, and this show is about boosting and amplifying the work that the newsletter does on press freedom, secrecy, and whistleblowers, digging into some headlines, covering some of the stories that the newsletter is not able to get to. And then I have an interview with a guest and friend, contributor to the Dissenter, who worked on a story for the Dissenter this past week. We go into a little bit more depth about Asif Rahman, a CIA analyst who was sentenced to 3 years and 1 month in prison for releasing documents on Israel's plans to strike Iran. Not recent strikes, but strikes from last year that were committed, that were engaged in by the Israeli military. And so, before I continue, let me encourage you to be a subscriber of the Dissenter if you are not already. Of course, if you're getting this show on June 16th, a couple days before it posts for everyone, you are already a supporter. And I thank you for keeping this newsletter strong, keeping the work that the Dissenter does going. But go to the Dissenter and donate. Or if you can't chip in a few bucks, please take some time to go to thedissenter.org and subscribe. Just for a few bucks a month, $3, you could support this show and you could help me push out this information about what is happening with whistleblowers, what's happening to journalists, how the US government is being more and more secretive every day, dismantling Freedom of Information Act offices, undermining the ability of citizens as well as journalists to access information about what the government is doing in our name. Now let's get to the headlines for this edition of the show. A Boeing whistleblower warned of Dreamliner problems prior to Air India crash. On June 12, 2025, a Boeing 787-8 Dreamliner flown by Air India crashed around 30 seconds after takeoff from Ahmedabad Airport in India. All 242 people on board, except for one individual, were killed. Marine Kasich, investigations editor for the American Prospect, reported that several Boeing engineers and quality control specialists had, quote, implored regulators, journalists, and airlines, quote, end quote, to examine problems with the Dreamliner. Cynthia Kitchens, a former quality manager, worked between 2009 and 2016 at the Charleston, South Carolina plant that is the Dreamliner's final assembly plant. She identified 11 planes between early 2012 and late 2013 that had quality defects, which most kept her awake at night. She said, quote, 6 of them went to Air India, end quote. The plane that crashed was delivered in January 2014 with its mid and aft fuselages produced in Charleston. Whistleblower John Barnett, who committed suicide in 2024, maintained that it takes 10 to 12 years for assembly line sloppiness to result in a plane crash. In fact, when Kitchens asked a boss if they would let their children fly on a plane with these flaws, the response she received was this: none of these planes are staying in America. They're all going overseas. A chilling response. The Justice Department, under both President Donald Trump and President Joe Biden, protected Boeing from prosecutions And most recently, Trump was responsible, his administration was responsible for what has been called a sweetheart deal with Boeing to help them escape a trial that was scheduled to begin this week. Next story. State parks whistleblower fired for revealing environmentally destructive plans. This is in Florida. Whistleblower James Gaddis, a Florida state employee, was fired by Florida officials after he released plans for 9 Florida state parks with golf courses, hotels, and other amenities, according to the Tampa Bay Times. He claims in a lawsuit filed under the Florida Whistleblower Act that Governor Ron DeSantis' administration retaliated against him. Allegedly, parks employees were told to be secretive, which frustrated Gaddis, who believed the plans would result in, quote, significant environmental destruction, end quote. The plans were revealed on August 20th, 2024, despite widespread condemnation from the Department of Environmental Protection in Florida and the governor's office. Gaddis allegedly was placed on administrative leave and then fired after he confessed to disclosing the plans in a memo. Continuing along, the Justice Department plans to only prosecute corporate bribery engaged in by foreign companies. After pausing enforcement of the Anti Bribery Foreign Corrupt Practices Act, the Justice Department announced that it will only initiate prosecutions focused on misconduct that impacts the United States' ability to compete with foreign companies. Whistleblowers have helped the government identify cases where bribery occurred by U.S. corporations, but the Trump administration closed half of the investigations into U.S. businesses overseas and pledged to no longer burden U.S. companies with such investigations. Moving on, Freedom of the Press Foundation sues State Department for memos on Rameza Ozturk. The Freedom of the Press Foundation filed a Freedom of Information Act lawsuit against the State Department for refusing to disclose a March memo that showed Tufts University graduate student Rameza Ozturk, who was detained by ICE, did not make anti-Semitic statements or make any statements in support of terrorism, specifically Hamas, which the U.S. government has designated a foreign terrorist organization. Freedom of the Press Foundation also sought another March memo that informed the Homeland Security Department that the revocation of Ozturk's visa had been approved under a discretionary authority. Ozturk is no longer in ICE detention, but still faces immigration proceedings that may lead to her removal from the United States. Journalists, YouTube streamers receive $398,500 in a lawsuit against the Denver police. Several YouTubers, journalists, and activists who were allegedly assaulted by Denver police during the 2020 Black Lives Matter protests. This was after Derek Chauvin murder, George Floyd. They received $398,500 collectively from the Denver City Council that approved this settlement during the past week. One of the people who sued the police is Siobhan Blades, the publisher of Yellow Scene magazine. According to the Denverite, she was covering the protests when tear gas was fired at her. It burned her skin and made it hard for her to breathe. Another individual, Carol Funk, who streams protests on YouTube, was pepper sprayed, suffered burns on her face and in her eyes. This is not the first time that Denver Police Department officers have retaliated against individuals for filming and criticizing the police, said attorney Andy McNulty. The Denver Police Department's persistent violation of the First Amendment should come as no surprise given Denver's consistent failure to discipline or fire officers who violate civilians' constitutional rights. Another story related to attacks on the press. ICE arrests woman after journalist interviews her in Minnesota, St. Paul to be specific. Journalist Georgia Fort of Black Press interviewed Isabel Lopez in the downtown office of the Monitor St. Paul. Following the interview, men in unmarked vehicles surrounded Lopez. They wrestled her to the ground and injured her shoulder. The men were from ICE, and she was arrested and subsequently charged with offenses related to a protest in South Minneapolis. Given that the Trump administration has created a climate where sources are afraid to speak publicly in fear of retaliation or arrest, Fort wonders what kind of surveillance had been carried out against her so that ICE could target Lopez. Fort condemned what happened, saying what is at stake is, quote, whether or not we still live in a place where people can speak freely without fear, and whether or not our local officials have any power to protect their constituents. It's about a federal administration yielding their force without care, concern, or compassion for the communities they are impacting. It's about the dwindling merit of our constitutional rights as Americans. Next story. San Francisco police detain student journalists covering ICE protests twice. Not only have police trampled on the First Amendment rights of journalists in Los Angeles, but in San Francisco, the San Francisco Chronicle reported that police detained two student journalists from UC Berkeley's Daily Californian, that's the university's student newspaper. 2 nights in a row, they did this on June 8th and June 9th. Arya Mukherjee and Sam Grotenstein were trying to document protests against U.S. immigration and customs enforcement in the Mission District and downtown San Francisco. They were wearing press credentials on June 8th, and yet Mukherjee was detained for 20 minutes and Grotenstein for over an hour. Their managing editor had to drive from Berkeley to get Grotenstein released. The following day, around 10 p.m., 2 hours after a protest ended, officers then surrounded these two student journalists again. They were standing with a small group. The police informed them they were under arrest. Though they identified themselves as press, both were held by police for 45 minutes. We asked them if we were allowed to leave. They said no, Mukherjee recalled. We asked them if we were arrested or detained. They said yes. We asked them why. They did not give us an answer. End quote. Apparently, the San Francisco police detained numerous journalists covering protests during the past week, and that is according to the Society of Professional Journalists and the First Amendment Coalition. And those are the headlines for this edition of the Dissenter Update. That brings us to the interview with Chip Gibbons, who is the policy director for Defending Rights and Dissent. He's been on the show before. He's working on a book on the FBI and its targeting of activists, its abuse of surveillance, and violations of civil liberties. And on this show, I get to talk to him about the reporting that he did for the Dissenter on Asif Ramen, as I mentioned at the top of this episode. And then we have a little bit of a conversation about Mahmoud Khalil. It was just Father's Day. He has a baby. He has not been with his child since they were born. And he was kept in detention despite the fact that a judge ordered his release. The Trump Justice Department is fabricating reasons to keep him in detention. So I spent some time talking about this as a First Amendment case and one that broadly impacts freedom of expression for everyone in the United States. So here's my conversation with Chip. All right, everyone. As I said, here I am with Chip Gibbons, the policy director for Defending Rights and Dissent. Welcome back, Chip.
Not welcome back. Thank you for having me back, Kevin. It's been a pleasure to do these. You come on my program sometimes, so I'm sort of confused. I'm like, oh, welcome back, Kevin. But welcome back.
We have a lot of mutually shared times together where we dig into the types of cases that this type of case that we're getting into right now. So you were at the Eastern District of Virginia courthouse in Alexandria to cover Asif Rahman's case, as was mentioned. And we've talked about his background, and people have read the article that you did on it for the Dissenter, and thank you again for the contribution. But like, I wanted to catch up with you after you did this reporting, just to get your sense of where you think this fits in with other Espionage Act prosecutions. And I know that you put some insights into your article about comparing it to Daniel Hale's case, comparing it to Chelsea Manning's case. But yeah, I just thought it would be very valuable to spend a little bit of time with you getting your response to where this fits in with the government's use of the Espionage Act against people who make these disclosures to Asif, I know, didn't leak to the press, but it was published online and widely available for the press to report.
Yeah, I mean, it was published by that Telegram channel. I'm blanking on the name of, like, Middle East Observer or Middle East
Spectator.
Middle East Spectator. It's a Telegram and Twitter channel. If you read the language that it uses to describe itself, it certainly presents itself as a news outlet. I'm not going to make a commentary on whether or not it deserves that distinction. I had never heard of it before this. I doubt you had ever heard of it before this, Kevin, unless you have a secret life on Telegraph or Telegram I don't know about. But the general content on the channels is very strange. It's clearly not English as a primary language. And there's a lot of news like Iran defends Jesus Christ from French atheist, or Iran gives ultimatum to the Kurds. That was a popular tweet. It never said what ultimatum, but it's clearly a social media outlet focused on niche stories about the Iranian government that seems designed to promote a positive image of them to Anglophone audiences. Beyond that, I don't know much about it. And they published these two documents about a likely Israeli strike on Iran. We are now in the midst of what is clearly an Israeli-Iran war that is extraordinarily dark and depressing moment as someone who has spent, 20 years, I think you have too, working to prevent a war with Iran. It's very, I know this is not the topic we came to talk about. It's very emotionally draining to be in the moment where this is finally happening, the thing that we have all feared for 2 decades. But yeah, they published those two stories about that. We've learned from the plea deal that Ramen did not give the documents directly through to them. He gave them to an unknown third party who presumably gave them to the Middle East Spectator. We know initially the Middle East Spectator said the documents came from a source of theirs, and they later stated they didn't get them from a source, but found them in a different Telegram channel or Telegram. I don't use that app. I don't really know that much about it. I know everyone else does. So we don't really know how they got there. And the other thing is, with the Espionage Act, there is no public interest defense. And judges are oftentimes very pro-national security state. So getting up there and saying, I did this to stop U.S. imperialism, which may be a defense that works well to you or me or the Dissenter audience, it doesn't play well in court, and it does not have any legal basis. But usually with cases like Chelsea Manning or Daniel Hale, there is some attempt to talk about the motives in court. I know Chelsea Manning's attorney at her sentencing read a letter from her where she quoted Howard Zinn. There's no flag big enough to cover the shame of killing innocent people. And he told the story of how there was a Christmas party and several civilians had been killed, and she couldn't celebrate Christmas thinking about their deaths, to sort of paint her as someone who was concerned with American foreign policy. Daniel Hale wrote both a very moving letter and gave an extraordinary moving speech in the courtroom about the drone program. I mean, obviously they both showed contrition for what they had done. You have to at that stage, but they brought in the fact that they were motivated by these foreign policy concerns. And at Daniel Hale's trial or sentencing, the judge actually labeled him a whistleblower, not for giving documents to The Intercept. He's like, you could have been a whistleblower without doing that, but he did label him a whistleblower. He did acknowledge he had these motives that were positive. With Rahman's sentencing hearing and sentencing documents, there is an allusion to a public interest motive, but it's very buried, and that feels extremely deliberate. The defense has mostly focused on the extent of his cooperation with the government, and most of the disputes between the defense and the prosecution have been how much time off he should get for that cooperation. And then there was an attempt to not justify what he had done. They were very clear what he did was very, very bad. Terrible, terrible thing. I don't find it that terrible. And that it was because he was under mental duress. And the mental duress was a mixture of personal, psychological trauma stemming from his wife having a miscarriage, as well as trauma from events in the Middle East that sort of brought back trauma he experienced as a CIA agent in Baghdad, where his life was in danger. And they produced an evaluation from a forensic psychologist who seems to specialize in military defendants who have been in the military, providing sort of mitigating evidence about their trauma and their stress to the judge under seal. We don't really know what was in that docket. Much of what was submitted was under seal. All of the letters from friends and family are under seal. That's not typical in these cases. I mean, obviously the classified documents are under seal. Obviously personal psychological information, psychiatric information is under seal, but I've never just seen a blanket seal of like the father's letters and the college friends' letters and things like that. And they really painted it as this guy who was under psychological duress, and as soon as he came to his senses, he aided the government. But buried in that, there was a statement by the attorney, Amy Jeffress, that he acted in the furtherance of saving lives and peace. And I asked her about that in the elevator after the sentencing. I said, do you want to comment more on those motives? And she said, no. I said what I want to say. I think I was very articulate, make me sound smarter than I was. Ha ha ha, the kind of joke people make to reporters. And then she said, thank you for listening close enough to notice that. And I have no idea what to make of that remark. But, you can't have your cell phone in the Eastern District of Virginia. They put them in this pouch. They used to put them in a locker. Now it's in this weird pouch. So we had no access to the news for the entire day. So the entire time we were sitting in a courtroom with someone who had leaked documents about an Israeli strike on Iran, you and everyone else were hearing the news that the U.S. was removing personnel from the Baghdad embassy in preparation for what we now knew was an imminent Israeli act of aggression against Iran. So here is someone who possibly, my read through the lines of what the defense has put forward is that he was in Iraq, he recognizes that war was a mistake, and he feared it was repeating itself. And he leaked these documents to try to prevent it. That's my speculative read on what's buried between the lines. So here we have somebody who acted altruistically to prevent an unnecessary war, and that war was coming to fruition while we were sitting in a courtroom talking about serenity, severity, the three factors of deterrence, and all these, and variances versus downgrades, and all these sorts of other technical legal terms. And it was just, the Espionage Act proceedings are always removed from the underlying motivation, underlying public interest story. That's part of the thing I try to do as a journalist, is to bring in the underlying story about why this person wanted to expose surveillance or war or whatever, torture. But in this case, it was particularly noted how divorced it was from what was happening in the outside world. And when Rahman got up and spoke, all he talked about was how much he loved the CIA. He's sorry he did damage to the reputation. He's sorry he put our troops in danger. He working for the CIA was the greatest honor of his life. He the CIA does really great work that we'll never know about because that's the nature of what they do. It was just this pro CIA speech, and I don't necessarily think it was forced. I think that was his feelings. And one of the really interesting things that struck me, I didn't put this in the article, but it did strike me, is that the defense attorney, Miss Jeffress, she said, you know, he gave up a career in finance to work for the CIA. He was an exemplary employee. How does someone who does that then, you know, leak these documents the way he did? It's very odd. And the judge also struggled to square those two facts together. And in order to explain this, they offered this psychological evaluation. But the thing I noted as someone who covers a lot of these cases is that's not an unusual profile, right? Like Daniel Ellsberg was an ardent Cold Warrior before he was the Pentagon Papers leaker. Thomas Drake, an immensely patriotic person, and I think is still extremely patriotic. And then in a number of cases, when we have whistleblowers, they are people who have an extraordinary sense of duty to their country and duty to the Constitution. And that duty motivates them to become involved with the US government, the US national security state, because they think they are serving those principles. And when they realize that government is at odds with the country's needs and the country's principles, that same sense of selflessness that motivates them to take on these positions at great personal risk. I mean, Daniel Ellsberg did his Marine Reserves tour of duty in Vietnam while working for the State Department. They then take a similar risk in becoming whistleblowers. And in that sense, I don't find the fact that Ramen was someone who loved this country so much he gave up a lucrative career in finance to work for the CIA as being odd, that then when he thought we were getting into an unnecessary war that did not benefit us, he would make the same sort of selfless act and put himself at risk. And I don't want to criticize the defense because they have an uphill battle, but I do wonder if they had introduced that profile as opposed to the sort of, you know, what they did, what the impact would have been. I don't know. I don't know if the judge would have been receptive to it, but I mean, I do feel like in 2025, if you say, I saw the Iraq war firsthand, it was a mistake, I want to prevent it, I think most people, Republican or Democrat, would find that admirable, right? Even if they don't find what you did admirable. I do think that in 2025, repeating the mistakes of the Iraq war is something you can say you were motivated by while still being a patriotic CIA super employee.
Right. You were mentioning Thomas Drake, NSA whistleblower. It's well known that he's a Republican at the time and is fully, you know, into responding to the 9/11 attacks and doing whatever is necessary to combat terrorism. That's the profile of CIA whistleblower John Kiriakou as well, of somebody who believes in the global war on terrorism and executing it to the fullest extent possible. So, yeah, I think you're on to something. So in the sentencing, as I mentioned in the introduction, he got 3 years and a month for a sentence. I know there was discussion about whether there will be special administrative measures imposed on Ramen, and you know the conditions of the kind of facility he's going to be serving this time in, within the context of prior Espionage Act cases, and then of course, like the Assange case, Julian Assange's prosecution offered a chance to truly educate people on how those accused of leaks are now being put under these national security incarceration measures. You know, why don't you get into some of the discussion about how Asif Ramen is going to be serving his prison sentence?
Yeah, and an author for antipolygraph.org wrote to me after we published the Dissenter piece with sort of addressing some of these issues. So the defense has requested he be placed at, I think it's Parksburg or Petersburg prison, which I looked up and is in Prince George County, Virginia, not Prince George's County, Maryland. I was perplexed by that briefly. Prince George must have been a very important person. Have all these counties named after him. And the prosecutor then chimed in and said there's a possibility he may be placed under SAM, Special Administrative Measures, which was an issue in the Assange extradition. And he said, that's Main Justice. There were several moments where we heard Main Justice was doing something, and it was clear the prosecutor in the case, Troy Edwards, was not terribly enthusiastic about it. And he said, if they ask for SAMs, and that's not my decision, that's Main Justice's, and that is something that the plea deal anticipates. There are discussions. He does acknowledge in the plea deal he could be placed under SAMs. There's a limited number of facilities he could go to, one of which is ADX, which I believe to be a reference to ADX Florence, which came up in the Assange extradition because that is a notorious prison. It is not in line with international human rights standards, to put it mildly, or a medium security prison in Maryland. And that if Main Justice seeks SAMs, then the prosecutor in the case will request the medium security prison in Maryland. And the judge took that under advisement. Ultimately, the judge has no say in where he goes. The prosecutor has no say in where he goes, and he has no say in where he goes. In the Daniel Hale case, for example, I believe the judge recommended Hale to a facility that specializes in some sort of mental health treatment, and instead he was sent to the communications management unit. This is it's not as bad as SAM's, but it's not great. It used to be called, I think, Guantanamo North. Isn't that the slang people used to use for it back during the Obama years? Guantanamo North. That's a bit of a
something like that, or Little Guantanamo.
It was Little Guantanamo.
Yeah, and there's two of these. There's one in Terre Haute, there's one in Marion County, Illinois, and he was in southern Illinois.
Yeah. And, you all of your communications, the outside world are monitored in real time. And, he was sent there, and the judge didn't ask for that. And he's the first Espionage Act defendant who is sent to a CMU, and the rationale for it was that he had committed a communications-based offense. And clearly, Mr. Rahman has committed a communications-based offense. And unlike Daniel Hale, he was not allowed out on bail for fear that there was nothing they could do to stop him from continuing to leak classified information, which is fascinating. The government was making an argument because, at the same time the government was presenting him in the worst possible light, he was cooperating at an unprecedented level with them.
I want to move on to one other thing very briefly, but it is important to be clear here that this got a lot of media coverage when it first happened. At least the documents did. And so there's been a steep drop off in interest over the last 6 to 8 months in Asif Rahman's case. And I'll take great pride with you that you were reporting and covering it, and that I and the Dissenter were able to do coverage of this case and chronicle it like we have covered other Espionage Act prosecutions. And I wish that there was more news media that would stay on top of this kind of a thing, because of how the Espionage Act can be wielded to suppress people's freedom of expression.
No, and I thank you for letting me write about this case. I think part of the reason why the interest dropped is there's a declining amount of interest from the media in Espionage Act prosecutions. Each one gets less interest than the last. And even really high profile and important ones like Chelsea Manning and Julian Assange, who I think could rightfully both be called the Press Freedom Act trials of the century in their own rights, did not get anywhere near the amount of attention from corporate media they should have gotten, at least in the US. But, with Daniel Hale's case, we saw at the beginning a struggle to give it attention. It's why I ended up writing those pieces for Jacobin, because at the time, no one was really talking about it. But I do think part of the reason why this case sunk under the radar was there was such an attempt by the judge, the prosecution, and the defense to sort of obscure the political context in which it was happening. I mean, if Rahman had gotten up and said, I was in Iraq, and I'm not saying he should have done this. I'm not telling what he should or shouldn't have done. He got a lesser sentence than Hale or Sterling, so clearly his defense strategy played off. I don't want to say it was a cynical strategy. I mean, this could be what he believes, and we don't really know why he did what he did. But if he'd gotten up and said, I was in Iraq with the CIA, that was an unnecessary war that hurt this country. We are repeating this again with Iran at Israel's behalf. I stood up to try to stop this. I think there would have been a much different media landscape. And I think you would have seen like Daniel Hale, you would have seen like Code Pink and anti-drone activists sitting in the public gallery when he was sentenced. Whereas this was just family. Matt Sludge from The Intercept, who also did a lot to cover this, an APY reporter and a Washington Post guy.
All right. So this probably could be its own segment on the Dissenter update, but for now, since it is in the news and I would probably address it anyway this week, let's just take a moment to have you bring in all the work you've done with Defending Rights and Dissent on Gaza and the threat to the First Amendment, as there are crackdowns on Palestinian protesters or pro-Palestinian protesters in the United States. And in particularly, the case of Mahmoud Khalil has been, we thought that the judge might have given it some kind of resolution in the last week. At least I think most observers would have thought that if his release was ordered, that could be a potential ending, but we're seeing that it won't be over. But maybe you just take a few minutes to speak about the stage of this case, where things are, and then the crucial significance of freeing Mahmoud Khalil.
Well, we could spend 5 hours on this, and I know you don't want to, so I will not talk for 5 hours, Kevin. So at Defending Rights and Dissent, we have been publishing the Gaza First Amendment Alert, which I urge you to sign up for, that covers this and other crimes against the First Amendment on a biweekly basis. I've also been covering this case as well as the other non-citizens detained for criticizing Israel for Jacobin. I welcome you to look at my Jacobin pieces. Mahmoud Khalil's case is very complicated because there are two cases happening in two different court systems at once. There's an immigration removal proceeding happening in immigration court. Immigration courts are not part of the federal judiciary. They're not what's called Article II courts created by the Constitution. They are part of the executive branch. Immigration judges work for Pam Bondi. The Attorney General is also typically the party seeking the deportation. An immigration judge sits below the Bureau of Immigration Appeals. The Bureau of Immigration Appeals is appointed directly by the Attorney General, and the Attorney General can modify or overrule any decision they make. So you basically have a system where everybody works for the party seeking the deportation, and that person can make the final determination. So Kevin, I'm going to seek to deport you, and I get a final say on whether or not you're deported. I don't think you'd find that very fair, but maybe you would. I don't know. In addition to that, he's also seeking what's called a federal habeas petition in federal court before an actual judge. Habeas corpus goes back to before the Magna Carta. It is enshrined as a fundamental right in the Magna Carta, so we are not just shredding the First Amendment, we're shredding the Magna Carta too. Great going, Donald Trump, although George Bush did that as well. And it is a challenge to the legality of his detention, not the removal, the detention. So the removal proceedings are heard in an administrative court that is a kangaroo court. The challenge to the detention is heard in federal court. And Mahmoud Khalil is being deported and detained on two bases. First is a Cold War era law that allows the Secretary of State to remove someone from the nation if their presence poses adverse foreign policy consequences. What does that mean? The law was severely amended in 1990, and the example Congress gave at that time of a situation in which this law would apply was the Shah of Iran. So if the Shah of Iran was in the U.S. would face threats to life and property of its people abroad. So the Secretary of State would have to remove the Shah. Mahmoud Khalil is not the Shah of Iran. He is a Columbia graduate student who engaged in political speech. And what the judge in New Jersey has said is that no reasonable person would know this law could apply to domestic speech. Therefore, it's unconstitutional as applied to him, or likely unconstitutional at the preliminary injunction stage. In addition to that, the government has since brought a charge that he misled the government in his immigration applications. This is a very convoluted and complicated charge, and the defense has offered evidence to refute it. Some of the misleading is that he didn't mention allegedly his work with the United Nations Refugee Relief. He didn't mention that he was a member of the Student Group of Columbia. It's unclear why he would have to bring that up. I mean, it's not a requirement. So the government's case there is quite weak. And the other dispute is over what dates he worked for the British government. And it seems like Mahmoud Khalil was accurate in describing when he worked for the British government, and the U.S. is just throwing things at the wall and see if they stick. In their removal proceeding, the judge has made no ruling on this charge. Instead, she ruled exclusively based on the foreign policy charge. And the reason for this is that under a 1999 ruling by the Bureau of Immigration Appeals, that's under Janet Reno and Bill Clinton, thank you, Democrats, if the Secretary of State makes a determination under the Cold War law that you're a threat to U.S. foreign policy, you are removable. There is no defense. There is no challenging it. There is no evidentiary threshold. All you have to show in an immigration court is that they signed this piece of paper. And it can be very perfunctory, as the ridiculous 2-page document Rubio has submitted. So once the Secretary of State signs this piece of paper, you are deemed removable. Just because you are removable does not mean you will be deported. In the immigration proceedings, you then go to the relief stage where you can request relief from deportation. But because the judge has made the ruling based on the foreign policy determination, she has not made a ruling on the other charge, and she has forbidden the defense from entering evidence refuting it. The defense tried to enter evidence refuting the second charge. That evidence has been seen in the federal court. You can read it at the Center for Constitutional Rights website. And she says, nope, I won't hear this evidence because the sole basis of his removability is the Rubio determination. The judge issued a preliminary injunction in relationship to the Rubio determination. He rejected a preliminary injunction in relationship to the second charge that he was misled on his, provided misleading information on his immigration application. But the judge noted, as I stressed very clear, that the sole basis of removability is charge number 1. So everybody thought that the government would appeal the judge's ruling. The judge put a stay on Khalil's release until Friday, giving the government a chance to appeal. Instead, the government has just merely said, and I think for a lot of people who are following this closely, and unfortunately that excludes most of the media who covers it, this move was not surprising. The government has now said, okay, the judge has said we cannot detain him based on Rubio's foreign policy determination. He is now being detained based on the second charge, which the immigration judge has refused to make a ruling on. So I'm not 100% sure what happens now, but if the judge's ruling is correct, it stands that he cannot be deported or detained under this, or the Rubio determination cannot constitutionally be applied to him, then I think the immigration proceeding has to start over again. Because we're past the removal proceeding stage and we refuse to hear the second charge and the first charge has been thrown out. I think that happens. This is rather not clear territory. This is actually more convoluted and confusing than the UK appeal process for Julian Assange. We were both so frustrated by that. And now I wish we were back in the days of the straightforward relationship of the UK court system to the Council of Europe, which was not straightforward at all. Just that was the joke.
Well, and so even with all of the legal cobwebs here, this isn't anything that someone wants to be entangled in for exercising their First Amendment rights,
Yeah.
publishing an op-ed or uh, whatever it might be that constitutes freedom of expression. We're seeing very clearly that Marco Rubio and others in the Trump administration will quickly round you up with the unidentifiable, masked secret police force that are on our streets now and targeting anybody who is immigrated to the United States but doesn't sufficiently exhibit politics that are supportive of Donald Trump's agenda.
Or
I mean,
Israel. I mean,
well, there you go. Yeah.
this is a foreign apartheid state's genocide, which is not to say that you should be deported or go to jail or arrested for not supporting Donald Trump's agenda. That is terrible. But we are shredding our First Amendment to protect a foreign apartheid state's war of extermination against an imprisoned people in Gaza. It is just grotesque beyond all belief. And now we have Israel trying to drag us into a war with Iran, which is not a war in our national interest. It is not the American people's war. I don't even really think it's in Israel's interest, but who knows? They're sort of a belligerent, armed garrison, settler, colonial apartheid state. Who can even define what their interest is? But I don't think having Tel Aviv bombed by Iran, which was the logical outcome of their act of aggression. Everybody knew it was going to happen next. I don't think if I was sitting in Tel Aviv right now, I would feel like it was in my interest to provoke and provoke and provoke and provoke and provoke the Iranians until they finally responded, as everyone knew they would. Which doesn't, justify dropping bombs on an urban area. I don't think sort of aerial bombing of a city can ever be justified. I think it inherently endangers civilian life. But this blood is on Netanyahu's hands, and our government is shredding our First Amendment to help him do this.
All right, Chip. Well,
yes.
Thank you for coming on the Dissenter Update for this discussion. And obviously, we'll have you back on again at some point because there's no shortage of stories for us to discuss. So thank you.
Thank you for having me.
All right. Thank you for tuning in to the Dissenter Update. Please take a moment to go to thedissenter.org if you are not a subscriber. I encourage you to subscribe to the Dissenter Update for a few dollars, and you'll get headlines every week, even when we don't produce a show, even when I don't have the time to sit down and do a full half-hour, 40-minute show. I'm pushing out the stories that I think people who read the Dissenter need to know about week after week. And so become a supporter. You'll get that. It's an extra for being a Dissenter Update subscriber or being a supporter of the Dissenter newsletter. And I'll be back in a couple weeks with another episode.